Hi, I'm John Strohmeyer with Strohmeyer Law, and today we're answering the question, what is a muniment of title? Well, a muniment of title is a unique Texas probate option that usually confuses anybody who's not a regular practitioner in Texas probate courts. This is an option that we use for families where the terms of a will are fairly straightforward and we just need to get the property in the right hands of the beneficiaries without a full administration. So if we're thinking about our two questions that we ask at the beginning of any probate, do we have a last will and how much administration do we need? We're going to answer the first question with yes, you have to have a last will to use a muniment of title. And two, how much administration do we need? The answer is going to be not much. So what does this look like? Well, we're going to avoid the administration, and we're not going to have a fiduciary appointed. So there won't be an administrator or an executor of the estate. What we are going to get out of this is we'll have the probate courts verify that the will is actually the last will, and instead of or once they've admitted it to probate, they're going to agree that there is just no need to have an administration. The terms are clear from the will. There are no debts that need to be settled. We can really just move on and have the will plus the order serve as enough for the beneficiaries to go and claim any of the assets. So taking the order plus the will to the bank to collect any bank accounts, filing a copy of that order in the last will in the property records to transfer title to any real property to the beneficiaries. Really, we need to follow the terms of the will, but we may not have any debts, or we shouldn't have any debts that need to be repaid. There's nothing that needs to be managed on behalf of the estate, so we don't want to incur those costs. And really, that's the benefit of the muniment of title. We're coming in and we're saying, we don't need to do much, but we do need to do something. Now, a potential problem with this is, well, what if we determine later on that we do need some administration? This was rectified in the 2019 Texas legislative session, where the legislature allowed and updated the Texas Estates Code to provide that beneficiaries can come back later, and if they had applied for a muniment of title, come back later and get a full administration if they need to. Previously, the courts weren't supposed to do this, though you might have been able to get it past some judges or get them to agree to modify orders to provide for an administration later on. So we're using muniment of title really in those cases where there's not a lot that needs to be done for the administration of an estate. We're looking to really just get title transferred over to the beneficiaries and get on down the road. We don't need to really do a lot to collect assets because we know where they are. We're also hoping that the beneficiaries aren't going to be fighting, because the problem is any one of those beneficiaries could potentially go into a bank and say, give me the full contents of the decedent's bank account. And it's then up to all the beneficiaries to sort out among themselves who's entitled to what. So if 3 people were entitled to an equal share of a bank account, potentially one of them could go into the bank, collect the entire asset, and then not bother to share with anybody. So there are some risks. Generally, you'd want to make sure everybody's on board before moving forward with this, but it is a great option if you're looking for just a minimum amount of administration without the full burdens of producing an inventory or any of the other disclosures that are required in a full administration.